You know, construction contracts are just a relationship. One of the most important provisions of a construction contract concerns how it's terminated. How do you get out of a relationship that's gone bad? Termination of a contract provisions are really important, but it's interesting that oftentimes that provision is ignored or only partially addressed in a contract. It's kind of unusual that that would be missing, because once something goes bad, you want to know how to exit. And that's what your termination provision does. It gives you the way out. If you don't have a termination provision, then the common law provides an answer for you. It's just not a very good answer. The answer is you have to show that there's a material breach. And the words material breach are not well defined. Essentially, the law says it's a fundamental error in the contract that goes to the heart or the purpose of the contract. In any given situation, it's going to be really hard to determine whether or not you've met that standard. And if you go forward and terminate on what you think is a material breach and you're wrong, you yourself can get sued for wrongful termination. And so it makes a lot of sense to have a well-written termination provision that addresses the following things. First, what is a breach? Spell out the things that either side could do that they shouldn't be doing that will constitute a breach. Second, spell out how the aggrieved party can provide notice to the wrongdoing party that they believe a breach has occurred. Third, does the party that made the error have an opportunity to cure, and how long would they be allowed an opportunity to fix the problem before a final termination provision or notice is provided terminating the contract? Contracts are not terminated easily. Even if you have a provision, it can't be a small error or an insignificant violation. But if you have a termination provision like that that goes through those provisions, you are going to be a lot better off if the contract and the relationship goes sour, because you'll have a process and a procedure to follow. One final issue to talk about is termination for convenience. Oftentimes this is more of an owner issue than a contractor's issue, but sometimes it could be a contractor's issue. Termination for convenience is no cause termination. And if the provision is in there in the contract, it lets, depending on how it's written, either side walk away from the contract. Usually there's some remedies or provisions that talk about what happens if either side wants to terminate for convenience. But the other tip is having a provision in your for-cause termination that says, if I've terminated incorrectly and I don't have a material breach, the parties agree that it will be treated as a termination for convenience. So it's kind of your get out of jail free card. If you have more questions, please give me a call. I'd be happy to talk to you about it. I'm at Saalfeld Griggs, and we've been doing this for over 30 years. One of the most ones, I want to talk to you about one issue today. I wanted to take a minute and talk about a couple of, and I'm out of memory bank at this point in time.